A pleasant day to everyone. Today we are going to discuss the first kind of defective contract, the rescissible contract. It is covered in Chapter 6 of the Law on Obligation and Contract, Articles 1380 to 1389.
Article 1380. Contracts validly agreed upon may be rescinded in the cases established by law. Rescissible contracts are ones that are legally effective and properly agreed to since all necessary conditions have been met. However, in certain circumstances specified by law, the right to rescission is provided in the interest of equity. The court may revoke them if there is harm or disadvantage to one of the parties or to a third party but they remain legitimate and enforceable. A rescindable contract has no flaws at all but its enforcement would be unfair due to some outside circumstances. Rescission is a remedy granted by law to the contracting parties and in some cases, third parties may use to obtain compensation for harms that a valid contract had caused them by putting things back in the state they were in before the contract was celebrated. See 8 Manrisa 748-749. The requisites of rescission. Number 1. The contract must be validly agreed upon. Number 2. There must be lesion or pecuniary prejudice or damage to one of the parties to a third person. Number 3. The rescission must be based upon a case especially provided by law. Number 4. There must be no other legal remedy to obtain reparation for the damage. Number 5. The party asking for rescission must be able to return what he is obliged to restore by reason of the contract. Number 6. The object of the contract must not legally be in the possession of third persons who did not act in bad faith. Number 7. The period for filing the action for rescission must not have been prescribed. Example scenario. X sues Y to reclaim a piece of property. In this case, the land is still under litigation and if Y sells it to a third party while the case is pending without X consent or the courts, the sale may be rescinded at X request if he succeeds in his claim to recover the land, unless the third party is in legitimate possession of the land in good faith.
Under Article 1381, the following are the rescissible contracts. 1. Contracts entered into on behalf of ward. Ward is we call a person under guardianship because of some incapacity. For example, A is a guardian of B who is a minor. A sells a property of B worth 10,000 for only 5,000. The contract of sale cannot be rescinded because the lesion is not more than one-fourth. However, if the property is sold for less than 5,000, B can rescind the sale by proper action in court upon reaching the age of majority. 2. Contracts agreed upon in the representation of absentee. An absentee who is free from his domicile, his whereabouts are unknown, without leaving an agent to manage his property. Likewise, the absentee must suffer a lesion of more than one-fourth of the value of the property of the contract entitled him the remedy of rescission. It must be noted that 1 and 2 refer only to the transaction by ward and absentee representative. As a general rule, the lesion does not invalidate contract except only in the cases specified by law.
The third case of rescissible contracts are contracts undertaken in fraud of creditors. So, to help you understand more, I'll give you an example. For instance, A is the creditor and B is the debtor. As a result, B owes A money. To prevent A from collecting B's debt, B will commit fraud such as selling all of his properties and declaring himself bankrupt. As a result, B will claim that he cannot pay A. In simple terms, the debtor defrauded the creditor. All of his property sales contracts are entered into in order to fraud the creditor so that he cannot pay him. In this instance, the creditor may bring an action for rescission of the contracts entered into by the deceiving debtor.
The fourth one is contracts, which refers to the things under litigation. It is the act, process, or practice of settling a dispute in a court of law. For example, A sues B for the recovery of a parcel of land. In this case, the land is a thing under litigation. In case B sells the land to C without the approval of A or of the court, then the sale is rescissible at the instance of A in case he wins in a suit for the recovery of the said land, unless C is in legal possession of the land in good faith. A can protect his right to the land by filing a notice of suspendence if B sells it to C without approval. A may also petition the court for the attachment or appointment of receivers for personal property. Fifth is the other instances. Some of the specific contracts subject to recessions are as follows. Article 1098 quoted that a partition, judicial, or extrajudicial may also be rescinded on the account of lesion when any one of the co-heirs receive things whose value is less by at least one-fourth of the said share to which he is entitled, considering the value of the land of the thing at the time they were adjudicated. Also, under Article 1470 quoted that gross inadequacy of price does not affect a contract of sale except as it may indicate a defect in the consent or that the parties really intended a donation or other act of contract. For the last instance of specific contracts subject to recession is under Article 1539. It quoted that the vendee may exercise the remedy of recession when the lack in the area of the real estate sold be not less than one-tenth of the stated, or when the inferior value of the thing sold exceeds one-tenth of the price agreed upon.
Article 1382 stated that payments made in a state of insolvency for obligations to whose fulfillment the debtor could not be compelled at the site they were affected were also rescissible. This article mainly refers to the payment, not the contract itself, wherein the debtors of possessions may not be enough to pay debts or fulfill obligations to the creditor. This article clarifies that a debtor's insolvency cannot be judicially declared or legally demanded, hence the interest of equity. The debtor was supposed to pay her two obligations perfected for all creditors, but ended up paying or doing the obligation to the first creditor while being insolvent. With this, payments for obligations paid by an insolvent debtor are rescissible by other creditors. Thus, they cannot legally oblige or compel the informer to pay or to do the obligation, as his possessions may not be enough to cover them. In order to affect this article, a debtor must have made a payment to a creditor while being insolvent, and other creditors were not consented by the former. Here is the example of Article 1382. Indigo, an insolvent person, pays his debt to Dandelion, a creditor. The two other creditors, Turquoise and Pemison, nonetheless cannot collect the debt from insolvent Indigo.
Article 1382. The action for rescission is subsidiary. It cannot be instituted except when the party suffering damage has no other legal means to obtain reparation for the same. Nature of action for rescission. Rescission is not a principal remedy. It is only subsidiary, meaning that it can be availed of only if the injured party proves that he has no other legal means aside from rescinding the contract to obtain redress for the damage caused, even if the contract is covered by Article 1381. If the damage is repaired, as in the case of lesion suffered by the ward or absentee, rescission cannot take place. Action for rescission is subsidiary, meaning if there is other remedy to obtain reparation, the rescission will not be available. When you seek rescission, it is only subsidiary remedy compared to annulment, which is a principal remedy. For further understanding, here is the example. Junie, the guardian of Mavi, a minor who owns a two-piece luxury yacht that costs 570,000 each, Junie sold the two luxury belongings of Mavi to Com for the combined price of 570,000. Supposedly, that should be 1,140,000 in total, but Junie sold the two yachts for only 570,000. In this case, the contract is rescissible since Mavi suffered lesion because the amount of the thing is more than one-fourth of the object. But what is the subsidiary here? It is when Mavi reached the legal age, he can rescind the contract. However, rescission is subsidiary, meaning you cannot seek rescission if you have other option. For example, if Kong is willing to pay another 570,000, then in this case, the contract is no longer rescissible.
Article 1384 states that rescission shall only be to the extent necessary to cover the damages caused. Under this article, only the creditor who brought action for rescission can benefit from rescission. This means that rescission will only be in favor of the plaintiff creditor and not all the creditor given the cases. So those who are strangers from the action, they cannot benefit from its effect. Additionally, the entire contract need not to be set aside by rescission if the damages can be covered by partial rescission. The extent of revocation should only amount to the prejudice suffered by the creditor. In this article, partial rescission was also mentioned wherein it shows that its main purpose is to make good on or compensate for the damages or harm done. Complete rescission will no longer be necessary or permitted if the circumstances of the case do not justify it. This policy on law is to preserve and protect the contract and not to extinguish it. For example, Jelly, the guardian of Marie, a minor, was ordered by the court to sell the two parcels of land valued 200,000 pesos each. Jelly sold to Bea the two parcels of land for 200,000 pesos only. In this case, the entire contract need not to be set aside by rescission. Rescission may only be applied to only one parcel of land. However, if Bea or Jelly decided to pay for the 200,000 pesos differences, the rescission will no longer be necessary or needed. For the second example, A is to deliver 1,000 packages of sardines to B amounting to 10,000 pesos. Due to the fault of A, 200 packages of sardines were lost amounting to 2,000 pesos. If we are going to apply what this article is all about, A may only pay 2,000 pesos to B because that is the extent of credit he caused to B.
Article 1385. Rescission creates the obligation to return the things which were the object of the contract, together with their fruits and the price of its interest. Consequently, it can be carried out only when he who demands rescission can return whatever he may be obliged to restore. Neither shall rescission takes place when the things which are the object of the contract are legally in the possession of the third person who did not act in bad faith. In this case, indemnity for damages may be demanded from the person causing the loss. This provision speaks about mutual restitution. Rescission creates an obligation of mutual restitution. On the first paragraph, the plaintiff or the complainant who demands the rescission, he must be able to record what has been received by virtue of that rescissible contract, and it also includes the fruits and the price of its interest to be returned. You need to have that ability to return the things you owe to the other party for you to demand rescission. There's exception in the second paragraph. If the things are legally in the possession of the third person who did not act in bad faith, so it means in good faith. So if the things are legally in the possession of the third person who's in good faith, you cannot get that thing from the third person. Take note that there is a requirement. First, it should be in legal possession. Second, it did not act in bad faith, or it should be in good faith. So in that case, indemnity for damages may be demanded from the person causing the loss. Since it can't be rescinded in contracts, indemnity for damages will be demanded from the guilty person. Example, A. The guardian sold the portion of land of B, who is minor, to C for 140,000 pesos, when the true value of the land is 200,000 pesos. Upon reaching the age majority, B can ask rescission for the sale on the ground of lesion. So if the contract is rescinded, C must return the land with the fruits received by him therefrom. B must return 140,000 plus legal interest of 6% from the date the action was instituted in the court. However, if B cannot return the price with its interest, then he cannot rescind the contract. If C sells the land to D, an innocent purchaser who's in good faith, who takes legal possession, rescission cannot also take place. The remedy of B is to file an action for damages against A, his former guardian.
Article 1386. Rescission referred to in numbers 1 and 2 of Article 1381 shall not take place with respect to contracts approved by the court. Contracts approved by the court. If a court approve a contract entered into by the guardian or the representative of the absentee, rescission cannot take place because it is valid whether there is a lesion or not. The law presumes that the court is acting in the interest of the ward or the absentee when it approves the contract in spite of the lesion. So these are contracts entered into by the guardian or the representative where the ward or the absentee suffers a lesion of more than one-fourth of the value of the property. If the contract is approved by the court, rescission cannot be availed, or even if lesion of more than one-fourth the value of the property is suffered by the ward or absentee. So lesion is a wound, injury suffered by a person who did not receive his rightful share. When a contract is entered into on behalf of a ward for an act of ownership, the approval of the court is required. So as regard as the contract dealing with an act of administration, court approval renders the contract valid, lesion or not lesion. So absent is approval, the contract is first of all whether there is lesion or not. So the contracts agreed upon in presentation of absentee. An absentee is a person who disappears from his domicile, his whereabouts being unknown, and without leaving an agent to administer his property. So likewise, the absentee must suffer a lesion by more than one-fourth of the value of the property. So object of the contract to entitle him to remedy of rescission. So the paragraph 1 and 2 of Article 1381 refers only to transaction by guardians and absentee representation. So for example, is X is a guardian of Y, a minor, and X sells the land worth 20,000 property of Y for only 15,000. So here the contract of sale cannot be rescinded because this lesion is not more than one-fourth unless the contract of sale is approved by the court. So however, if the property is sold for less than 15,000, Y can rescind the sale by proper action in court upon reaching the age of majority.
In Article 1387, all contracts by virtue of which the debtor alienates property with gratuitous title are presumed to have been entered into in fraud of creditors, when the donor did not reserve sufficient property to pay all debts contracted before the donation. Alienations by onerous title are also presumed fraudulent when made by persons against whom some judgment has been rendered in any instance or some writ of attachment has been issued. The decision or attachment need to refer to the property alienated and need not have been obtained by the party seeking the rescissions. In addition to these presumptions, the design to defraud creditors may be proved in any other manner recognized by the law of evidence.
According to Article 1387 of the first paragraph, all contracts that is gratuitous, that alienates property, it is presumed that it is fraudulent. Before the donation happens, the donor knew that he or she has many debts to pay and yet still willingly donated all of his or her properties even though it isn't sufficient to pay off his debts. According to Article 1387 of the first paragraph, for example, N made a donation to P containing her house and a car. But even before the donation happens, N has many debts to pay to S, L, and Y. The remaining property of N is insufficient to pay her debts. Now, for this example situation, the donor knew that she has debts to pay but still made the donation without any reservation. Now, there is a presumption to defraud her creditor. According to Article 1387 of the first paragraph, it is presumed to be fraudulent.
Under paragraph 2 of Article 1387, it says that when an owner is titled that alienates property, it is presumed that it is also fraudulent. However, the presumption of fraud will only arise in cases the property was made by person whom some judgment has been issued against him. Example, N made a sale containing her house and car to P, but even before the sale happens, N has debts to pay to S, L, and Y. The remaining property of N is insufficient to pay the debts to S, L, and Y. In this situation, under the second paragraph of Article 1387, the sale to P is not presumed fraudulent. The creditors of N, which are S, L, and Y, must show that the conveyance will prejudice their right. The presumption of fraud will only arise if the sale is made by N after some judgment has been issued against him. Suppose again that N sale to L of another parcel of land that has not been attached, while Y, the creditor of N, obtains a writ of attachment in his favor, then the sale to L is presumed fraudulent because the law states that the decision or attachment need not refer to the property alienated. S, another creditor of N, has the right to rescind the sale to L because the law says that the decision or attachment need not have been obtained by the party seeking the decision.
The third paragraph says that the design to defraud creditors may be proven any other manner recognized by the law of evidence. Therefore, the presumption may be rebutted by adequate proof. Courts have laid down certain rules by which the fraudulent character may be determined. The following are some of the circumstances attending sales which have been denominated by the court's badges of fraud. First, the fact that the consideration of conveyance is fictitious or is inadequate. Second, a transfer made by a debtor after suit has been begun and while it is pending against him. Third, a sale upon credit by an insolvent debtor. The fourth, evidence of large indebtedness or complete insolvency. Fifth, the transfer of all or nearly all of his property by a debtor, especially when he is insolvent or greatly embarrassed financially. Sixth, the fact that the transfer is made between father and son where there are present other of the above circumstances. And the seventh, or the last, the failure of the bandee to take exclusive possession of all the property. So, at least three of the circumstances that I mentioned indicated as determinative of the existence of fraud.
In Article 1388, which states that whoever acquires in bad faith the things alienated in fraud of creditor shall indemnify the latter for damages suffered by them on account of alienation. Whenever, due to any cause, it is impossible for him to return them. There are two or more alienations. The first acquirer should be the liable first and so on successively. Before we proceed, let us know the meaning of good faith and bad faith. Speaking of bad faith, it is a purposeful fraud or dishonesty to meet an obligation. It doesn't just signify carelessness or poor judgment. It merely denotes a breach of an specified duty caused by some sort of ulterior motivation, interest, or malice and deception in nature. On the other hand, a purchaser who acts in good faith is the one who obtains another person's property without the knowledge of that person who has a right to or interest in and pays a reasonable price for it at the same time of purchase. The purchaser who acted in bad faith and acquired the object of the contract alienated in fraud of creditors must return the same if the sale is rescinded, and should be possible for him to return it due to any cause, he must indemnify the former. So, for example, to defraud C, S sold his car to B. B knows S purpose. B sold the car to D, who acted in bad faith, and D sold the car to E, who acted in good faith. We can identify here the alienation in this example. So, as per the definition, the first acquirer, which is B, should be the liable first, and so on successively. As what I have mentioned earlier, the purchaser who acted in bad faith and acquired the object of the contract alienated in fraud of creditors must return the same if only the sale is rescinded and possible for him to return it unless he must indemnify the former.
Article 1389, the action to concession must be commenced within 4 years. For person under guardianship and for the absentee, the period of 4 years shall not begin until termination of the former's incapacity or until the domicile of the latter is known. The general rule is action to concession must be commenced within 4 years from the date the contract was entered into. The exemptions are: first, the period for individual under guardianship shall start when the incapacity ends. Second, for the absentee from the time of domicile is known. When a complaining party is a third person who has no participation in the contract, the prescriptive term is 4 years reckoned from the discovery of the fraudulent contract, or if a real property is involved, from the registration therefor. The person entitled to bring action are the: first, injured party or default creditor; second, his hers assigns or successors in interest; third, the creditors of the 1 and 2 who are entitled to subrogation. For example, L is a representative of K who is an absentee. L sold to Y the property of K for 25,000. The value of the property is 50,000. K suffered a lesion and she can rescind the contract. If K's domicile is known, the 4 years to claim rescission begin.
Iringan versus Honorable Court of Appeals and Antonio Palau. General Register number 129107, September 26, 2001. The facts of the case. On March 22, 1985, private respondent Antonio Palau sold to petitioner Alfonso Iringan an undivided portion of lot located at the poblacion of Tugigaraw. The parties executed a deed of sale on the same date with a purchase price of 295,000 pesos payable as follows: 10,000 pesos upon the execution of this instrument, and for this purpose, the vendor acknowledged having received the said amount from the vendee as of this date: 140,000 pesos on or before April 13, 1985, and 145,000 pesos on or before December 31, 1985. When the second payment was due, Iringan paid only 40,000 pesos. Thus, on July 18, 1985, Palau sent a letter to Iringan stating that he considered the contract as rescinded and that he would not accept any further payment, considering that Iringan failed to comply with his obligation to pay the full amount of the second installment. On August 20, 1985, Iringan, through his counsel attorney Hilarion L. Aquino, agreed to the rescission but asked for the reimbursement of the 50,000 pesos cash received by Palau and the geodetic engineer's fee, attorney's fee, and current interest. In response, Palau refused to the reimbursement claimed by Iringan. On February 29, 1989, Iringan proposed that the 50,000 pesos that he had already paid Palau be reimbursed, or Palau could sell to Iringan an equivalent portion of the land. Still, Palau refused. Thus, they failed to reach an agreement. On July 1, 1991, Palau filed a complaint for judicial confirmation of rescission of contract and damages against Iringan and his wife. In a decision dated September 25, 1992, the Regional Trial Court of Cagayan Branch 1 ruled in favor of Palau and affirmed the rescission of the contract. The issue of the case: is the contract of sale validly rescinded? The ruling of the case. On the first issue, The contract of sale is validly rescinded by the provisions of Article 1592 regarding the sale of an immovable property. Article 1592 requires the rescinding party to serve judicial or notarial notice of his intent to resolve the contract. A judicial or notarial act is necessary before a valid rescission can take place, whether or not automatic rescission has been stipulated. Since Iringan did not oppose the intent to rescind the contract, stating that he considered the contract of sale rescinded, Iringan in effect agreed to rescind the contract and had the legal effect of mutually agreed rescission.
Maria Antonia Siguan versus Rosa Lim, Lindy Lim, Ingrid Lim, and Neil Lim. 318 SCRA 725 GR number 134685, November 19, 1999. These are the facts. On 25th and 26th of August 1990, Rosalim issued two Metrobank checks with a sum of 300,000 pesos and 241,668 respectively payable to cash. Upon presentment by Maria Antonia Siguan with the Rowi Bank, the checks were dishonored for the reason account closed. As a consequence, a criminal case were filed against Lim with RTC Cebu City for issuing two bouncing checks. Meanwhile, on July 2, 1991, a deed of donation conveying the following parcels of land and purportedly executed by Lim on the 10th of August 1989 in favor of his children Lindy, Ingrid, and Neil was registered with the Office of the Register of Deed of Cebu City. First, a parcel of land situated at Barrio Lahug, Cebu City, containing an area of 563 square meters and covered by TCT number 93433. Second is a parcel of land situated at Barrio Lahug, Cebu City, containing an area of 600 square meters and covered by TCT number 93434. Third one is a parcel of land situated at Cebu City, containing an area of 368 square meters and covered by TCT number 87019. And the fourth one is a parcel of land situated at Cebu City, containing an area of 511 square meters and covered by TCT number 87020. New transfer of certificates of the title were thereafter issued in the names of the donees. On 23rd of June 1993, petitioner filed an action Paulina against Lim and her children before Branch 18 of the RTC of Cebu City to rescind the question deed of donation and to declare as null and void the new transfer certificates of the titles issued for the lots covered by the question deed. Maria Siguan claimed therein that sometime in July 1991, Lim, through a deed of donation, fraudulently transferred all of her real property to her children in bad faith and in fraud of the creditors, including her. That the respondents conspired and confederated with her children in antedating the question deed of donation to petitioners and other creditors' prejudice, and that Lim, at the time of the fraudulent conveyance, left no sufficient properties to pay her obligation. On the other hand, Lim denied any liabilities to the petitioner. She maintained that it was not antedated but was made in good faith at a time when she had sufficient property. Finally, she alleged that the deed of donation was registered only on 2nd of July 1991 because she was seriously ill. The issue is whether the deed of donation executed by Rosalim in favor of her children be rescinded for being in fraud of petitioners Maria Antonia Siguan. This is the decision or ruling. In its decision of 31st of December 1994, the trial court ordered the rescission of the questioned deed of donation, and declared null and void the transfer of certificate of titles issued in the names of private respondents Lindy, Ingrid, and Neil Lim. Ordered the Register of Deed of Cebu City to cancel the said titles and to reinstate the previous titles in the name of Rosalim, and directed the limbs to pay the petitioner jointly and severally the sum of 10,000 pesos as a moral damages, 10,000 pesos as attorney's fee, and 5,000 pesos as expense of litigation. On appeal, the Court of Appeals, in a decision promulgated on 20th of February 1998, reversed the decision of the trial court and dismissed the petitioner's action Paulina. It held that two of the requisites for filing an action Paulina were absent, namely, the first one is there must be a credit existing prior to the celebration of the contract. The second one is there must be a fraud or at least the intent to commit fraud to the prejudice of the creditors seeking the recession. Furthermore, in Article 1383 of the Civil Code provides that the action for recession is a subsidiary remedy that cannot be instituted except when the party suffering damage has no other legal means to obtain reparation for the same. The term subsidiary remedy means the exhaustion of all remedies by the prejudiced creditor to collect claims due him before recession resorted to. It is therefore essential that the party asking for recession prove that he exhausted all other legal remedies to obtain satisfaction of his claim, since Siguan neither alleged nor proved that she did so. Her action for the recession of the questioned deed is not maintained even if the fraud charged actually did exist.
MR Holdings Limited Company versus Sheriff Carlos P. Bacar, Sheriff Ferdinando Mahandusay, Solid Bank Corporation, and Markhaber Mining Corporation. GR number 138104, April 11, 2002. On November 4th of 1992, a principal loan and complementary loan agreement were executed between Asian Development Bank, a multilateral development finance institution, and Markapper Mining Corporation to extend the loan to the latter in the aggregate amount of 40 million US dollars to finance the latter's mining project at Santa Cruz, Marinduque. On even date, ADB and Blazer Dome Incorporation, a foreign corporation that owns 40% of Mark Copper, executed a support and standby credit agreement whereby the latter agreed to provide Mark Copper with cash flow support for the payment of its obligation to ADB. To secure the loan, Mark Copper executed in favor of ADB a deed of real rights and chattel mortgage dated November 11, 1992, covering all of its properties and assets in Marinduque substantially. It was registered with the Register of Deeds on November 12, 1992. When Markapper defaulted in the payment of its loan obligation, Laser Dome, in fulfillment of its undertaking under the Support and Standby Credit Agreement, and presumably to preserve its international credit standing, agreed to have its subsidiary corporation, petitioner MR Holding Limited Company, assumed Markapper's obligation to ADB of 18,453,450.0 US dollars. Consequently, in an assignment agreement dated March 20, 1997, ADB assigned all its rights, interests, and obligation under the principal and complementary loan agreements to the petitioner. On December 8, 1997, Markapper likewise executed a deed of assignment in favor of the petitioner, Under its provision, Mercaper assigns, transfers, cedes, and conveys to the petitioner its assigns and/or successors in interest all of its properties, mining, equipments, and facilities. Meanwhile, on May 7, 1997, Solid Bank Corporation obtained a partial judgment against Mark Hopper from the RTC Branch 26 of Manila, the decretal portion of which reads, wherefore premises considered partial judgments is hereby rendered ordering defendant Mark Hopper Mining Corporation as follows to pay the plaintiff 52,970,756.89 pesos plus interest and charges until fully paid. To pay an amount equivalent to 10% of the above stated amount as attorney's fees and to pay the cost of the suit. Upon Solid Bank's motion, the RTC of Manila issued a writ of execution pending appeal directing to Carlos P. Bahar, respondent sheriff, to require Marcapper to pay the sums of money to satisfy the partial judgment. After that, respondent Bahar issued 2 notices of levy on Marcapper's personal and real properties and its stocks of scrap iron and unserviceable mining equipment. Together with Sheriff Ferdinand M. Handusay, also respondent of the RTC, Branch 94, Boac, Marinduque, respondent Bahar issued 2 notices setting the public auction sale of the levied properties on August 27, 1998 at the Marcaper mine site. Having learned of the scheduled auction sale, the petitioner served an affidavit of third-party claim upon respondents' sheriffs on August 26, 1998, asserting its ownership over all Marcaper mining properties, equipments, and facilities by virtue of the deed of assignment. On October 6, 1998, Judge Ansaldo denied the petitioner's application for a writ of preliminary injunction on the ground, among others, that the petitioner has no legal capacity to sue, it being a foreign corporation doing business in the Philippines without a license. This decision was affirmed and sustained by the Court of Appeals. Petitioner contends that it has the legal capacity to sue and seek redress from Philippine courts as it is non-resident foreign corporation not doing business in the Philippines and suing on isolated transactions. But the appellate court ruled otherwise. It stressed that while the petitioner may just be an assignee to the deed of assignment, it may still fall within the meaning of doing business, where a single act or transaction, however, is not merely incidental or casual, but indicate the foreign corporation intention to do or other business in the Philippines. Said single act or transaction constitute doing on or engaging in or transacting business in the Philippines. Was the deed of assignment between Mark Copper and MR Holding executed in front of creditors? Under Article 1387 of the Civil Code of the Philippines, the assignment agreement and the deed of assignment were executed for variable considerations. It can be seen from the assignment agreement is the fact that the petitioner assumed that payment of 18,453,450.12 US dollars to ADB in satisfaction of Markuper's remaining debt as of March 20, 1997. Solid Bank cannot deny this fact considering that a substantial portion of the payment, 13,886,791.6 pesos, or US dollars rather, was remitted in favor of the Bank of Nova Scotia, its principal stockholder. The facts that of the case so far show that the assignment contracts were executed in good faith. It bears reiterating that as early of November 4, 1992, Placerdome had already bound itself under the support and standby credit agreement to provide Mercaper with cash flow support for the payment to ADB of its obligation. where Mercapper ceased operation because of disastrous mine tailing spill into Boak River and ADB pressed for loan payment. Dome agreed to have its subsidiary, herein petitioner pay ADB the amount of 18,453,450.12 US dollars. It is inconceivable that ADB, a reputable international financial organization, will conspire with Mark Copper to feign or simulate a contract in 1992 just to defraud Solid Bank for its claim 4 years thereafter. And it is equally incredible for the petitioner to be paying the huge sum of 18,453,450.12 US dollars to ADB only for the purpose of defrauding Solid Bank of the sum 52,970,756.89 pesos. The conveyance is not fraudulent as we cannot see how Solid Bank's right was prejudiced by the assignment contracts considering that substantially all of Marcopper's properties were already covered by the registered deed of real estate and chattel mortgage executed by Marcopper in favor of ADB as early as November 11, 1992. As such, Solid Bank cannot assert a better right than ADB, the latter being a preferred creditor. It is a basic that mortgage property answers primarily the mortgage credit, not for the judgment credit of the mortgagor's unsecured creditor. Considering that the petitioners assumed Markuppers that to ADB, it follows Solid Bank's right as judgment creditor over the subject properties must give way to that of the former. So that's it for the third case. Thank you.